Back. In case you just tuned in, you're still watching Daybreak on Trust TV. Now, controversy over the judgment of a federal high court, UMUAHIA, which declared Section 84, subsection 12 of the Electoral Act 2022 unconstitutional, null and void, has continued to rage. Now, the new statutory provision had prohibited political appointees from voting as delegates in a party conventions or congresses for election or nomination of candidates. Now, is this a booby trap for APC? That is the big question here. And we have a senior lawyer, a barrister, Mainasara Kogo Umar, here in the studio with us. And he's also a member of the All Progressives, a barrister here in the studio with us. Good morning and welcome.
Good morning, viewers.
All right. We also have a member of the All Progressives Congress, Ayo Oyalowo, and to help us look at this topic, he's in the studio with us here as well. Good morning and welcome.
Good morning. Thank you for having me.
Nice to have you. Yes. We'll also be joined virtually from Ado Ekiti by the Program Officer, Elections, Yaga Africa, Paul James. But before then, we'll just stick to, our guests in the studio to give us some perspective on this particular topic.
Okay, I think I'm going to start with Barrister Mainasara. Now, as a lawyer, could you give us, your thoughts on this ruling?
Well, professionally speaking, as a lawyer, we are bound by the decision of the court. But when you analyze it jurisprudentially speaking, and in the practical sense of it, then you can comment regarding those areas that you see visible negativities in the judgment. For example, this is a judgment given without the relevant prerequisite parties involved. One of the parties that ordinarily must have been involved will have been the National Assembly, where the National Assembly was the one that made the law. And then secondly, it will have been very, very important that INEC should have been involved as a party to the suit, because ultimately INEC will be the umpire under which the fair play of the judgment or otherwise will be predicated. Now, what was the basis upon which Section 84, subsection 12 of the Electoral Act emanated? Before this time around, or right up to this time around, we are seeing a culture that is trying to stampede on democratic tenets. In other words, we are seeing emergence of one executive officer, for example, governor or president. He will have a number of 1, 2, 3, 4, or up to 5,000 appointees, or even more, because there is no limitation regarding how many number of appointees he will appoint. He will have his commissioners, special assistants, special advisors, senior special assistants, PAs, and the rest. Now, all these people are christened as delegates, and by virtue of which they come en masse and do His Excellency's bidding. Wherever His Excellency says, vote for this person, they normally go. So you'll discover that the overwhelming preponderance of the basis of winning any election is the interest of the governor, or in the interest of the president, because they are the ones that are having greater number of the delegates under their control. So the National Assembly now looked at it and said, it is very, very imperative we sanitize the political system. Even though in the Constitution, when you take sections 221 down to 227, particularly 223, talks about the operational conduct of parties. But that is paradoxical, because in the real sense of the practice, you don't see that being practiced. So the National Assembly decided to sanitize the system by bringing that, so that all those political appointees will naturally clear away if they are having any interest, especially regarding participation in party convention or party whatever activities that should be. That is highly commendable. Then His Excellency the President, under Section 130, is the Chief Executive Officer of the Federation and Commander-in-Chief. By virtue of the powers given to the National Assembly under Sections 4, 11, 8, and 9, that power was not unlimited, because the power was limited upon the sanction of the president, whether he approves whatever they legislate or not. The president voluntarily signed and said, I approve. Then suddenly he realized that aspect. Where was the Attorney General who should have advised the president ab initio regarding the rightness or otherwise of that legislation? But whatever is it, it has become law. Now, the Attorney General of the Federation, and even though he's a defendant in the suit, up to this moment we have not been informed who are the plaintiffs in the suit.
Okay.
Who are those people that filed the action? But the most important thing we should realize is that that particular judgment is not in stricto sensu in tandem with the constitutional violation that is being perpetrated by many people. The sections, permit me to make this very important listing. The sections 66(1), 107, 137, 156, and 182, those sections in the Constitution are not referring to matters of political appointees. Because the wordings of the Constitution, permit me to read what the Constitution says clearly for people to understand. It says that if he is a person employed, the word employed is used, employed in the public service of the Federation or any state, and has not resigned, withdrawn, or retired from such employment 30 days before the date of election. Now, this is talking about those under employment, career civil servants under employment. Those are the ones that the law is talking about, the Constitution is talking about. There are three categories of officers in the government service. There are those employed, career civil servants that will serve for a period of 60, 65 years of their age, or 30, 35 years of their years of service. These are the ones this section is talking about. Then political appointees are not under employment. Political appointees are clearly mentioned in sections 147, 150, 153, 154, and 176, 171 of the Constitution. These are appointees that have to do with maybe commissioners, maybe ministers, special assistants, special advisors. These are not under employment because they are under the whims and caprices of the interest of the person that appoints them. So whereas those elected people, the elected people are those mentioned under section 66, 107, 137, 156, and 182. In other words, governor, minister, governor, president himself, National Assembly members, state assembly members, local government chairman and councillor. These are the elected whose tenure is clearly defined. Then the employed people are the ones. So the point I'm making is that the section under the Constitution is not talking about political appointees. It is that lacuna, that gap, that did not talk about political appointees that the National Assembly really did
Barrister,
the job
would have
of
to cut you off here.
Yes.
Our virtual guest has actually joined us all the way from Ado Ekiti. He's a program officer, elections, Yaga, Africa, Paul James. Okay. All right, he seems to be offline right about now. All right, let's move the next question to Mr. Ayo in the studio. Now, a lot of people seem to have a problem with the suits being filed, in Abia State and, not, at the Supreme Court or any other court in, the Federal Capital Territory.
Well, while I am not a lawyer, it looks like the judiciary is allowing itself to be used in very funny ways. I enjoy what the learned gentleman has said, and you can see clearly it is not emotional here. He's talking clearly on the issue of the law. But when you look at what has been happening in the past few weeks, let's look at what happened in Ebonyi State, where the governor had a case against him, which was dismissed, rather than the whoever filed the case to go to the appellate court. They came to another Abuja High Court. Just yesterday again, the Cross River State issue came to Abuja High Court, not Calabar. Now, the Attorney General's case that, I don't know who filed that case, but you see, there's a lot of funny things going on in our courts, and they are allowing themselves to be used. Like you rightly said, it should have been the Supreme Court in Abuja that will interpret the Constitution. But what did they do? Jankara orders just flying everywhere, creating unnecessary upheaval for the people. We used to believe that the judiciary was the last hope of the common man. Now, I'm not sure that is the case anymore. It looks like people can just bamboozle the judiciary, and the judiciary is allowing itself to be used by anybody that wants to use it. Clearly, we don't know who filed this case. We don't know what local standing this person has. And within hours of the pronouncement, the Attorney General has agreed that he's going to obey. So it tells you that people are playing games using the courts. And unfortunately, the courts are making themselves available for all manner of clandestine moves, which on the long run may have adverse effect on our democracy. And the moment the court becomes a playground for whoever can afford it, people lose hope in that aspect of our lives, then we are not better than animals in the jungle anymore, because that is what differentiates us. Rather than me taking personal physical action, I should go to the court if I'm aggrieved. But if people no longer have hope and trust in the court, knowing fully well that all manner of Jankara injunction can be sought and gotten, then we are getting to a place, we are entering very dangerous grounds in our democracy. And those are grounds I don't hope we get to. But we are clearly moving there when things keep happening in a way that we cannot understand. Now, a case for the Cross River that I said yesterday had quickly been dispensed with in Abuja, not in Calabar. Meanwhile, you have 14 legislators in Edo State who the governor have refused to swear in and inducted. Their case is still in court. No court has heard it. Their tenure is going to end next year. They've not been sworn in after 3 years. And the court is dragging. But some other Jankara cases will be taken to the court within 2 days, 3 days, 4 days. Pronouncement will be made. There's a problem somewhere. And I think the NJC needs to sit up and clean up its act. Courts should not become where anybody can just go and get whatever they want because maybe they are connected or they can pay or they are something. I mean, it is just not acceptable. It is not the right thing to do. It is a threat to our democracy. It's a threat to our continuous living together. It's a threat to all our collective aspirations as a people if the court becomes the playground or the plaything of a few people who can afford it.
Well, Barrister Mainasar, you've heard what Mr. Ayo said. It seems from his response there is a sort of bias in Nigeria's judiciary. What really is the problem?
No, you know, where a fish gets rotten from the head, a fish begins to get rotten from the head. In a situation whereby, look at, for example, this case that we are examining, immediately the judgment was pronounced. The Attorney General said, yes, we are ready to implement it immediately. There is no room for appeal. I don't see any wisdom in his rush. How many cases have been delivered, some of them against the government especially, that he now deliberately kept them under the carpet, and up to now, they have not been implemented. If he is praised by the journalists, he will say, hey, we are studying the cases, first of all. We are studying, we are analyzing the cases before we now get advice on what to do. Why is it that he didn't study this one? He is not ready to think of advice. And besides, in our own legal system, there is always room for appeal whenever a judgment is given. Sections 230 to 304 of the Constitution has given avalanche of stages of appeal up to the Supreme Court level. The parties are at liberty, and like I said, the judge shouldn't have even gone ahead. There is what we call in law amicus curiae. In other words, friends of the case. If there is a case that is relevant to Mr. X, and he visibly discovered that Mr. X had not been joined as a party, you invite him as a friend of the case for the purpose of that decision. That is what we call amicus curiae. National Assembly and the INEC, and even possibly the political parties should have been invited at the decision. We have not known up to now who is the plaintiff, like I said. And then for the Attorney General, who is on the side of the defense, to rush and say we are in agreement of it, we are going to implement it, I mean, it's bizarre. Attorney General, you are Attorney General of the Federation. The Federation simply means Every person in the country has stake in what you do. The governors have stake, the local government, the citizenry. You are not Attorney General of the federal government. You are not Attorney General of the ruling party. You are not Attorney General of only the presidency. You are Attorney General of the entire country. That is the difference between the DC. And then besides, when you take the position of the Constitution, under Section 147, you are made a minister. Under Section 150, you are the Attorney General. But there is something that is clearly said under Section 174, that in the discharge of your office as Attorney General of the Federation and Minister of Justice, you should carry it, one, in the public interest, in the interest of the public. Two, you should carry it in the interest of justice, natural justice, equity, and fair play. And number three, you should not use it by means of legal abuse of legal processes. By the time you take these three, and then you just oppose it with a rush to implement the decision, and then trying to say that there is no room for appeal. How can you say there is no room of appeal when the Constitution clearly has given the provisions that whenever the judgment you are not satisfied, you are at liberty to go on appeal? I expect the National Assembly now, I expect the Attorney General should be at the lead because he is the defender of the citizenry. They should appeal this judgment, and then the greater majority, even civil society groups, should entrench interest, politicians should entrench interest, so that they will be able to get this. My own apprehension has to do with even the APC convention coming up this week. By the time you now decide that you foreclose the possibility of appeal at all, and then finally they get the basis to appeal against it, and even succeed in getting stay of execution, it will bring another boomerang on the ruling party. So the earlier these things are solved, the better. I have not seen anywhere in the history of Nigeria where political appointees will be given the discretion, say, please, if you so wish, resign. Whosoever cannot perform very well, which glaringly we are seeing it in the country, the performance of those that are political appointees are not up to the average level of the satisfaction of an average common man. The president ought to do the needful. You ought to reject the cabinet periodically. I have never seen a situation whereby you refuse to reject the cabinet to such an extent, giving them the leverage, say, if you so wish to do so, you should resign. I don't think our democracy has descended to such a level. Even before the judgment, the Attorney General was there in the news. He said that, no, he will not resign. He cannot resign until he finishes his tenure. Who told you your appointment is a tenure appointment? Your appointment is not a tenure appointment.
This next question is still for you.
Yes.
Now, the court have actually said that, that particular clause, 84, subsection 12, is unconstitutional. Now, is it possible to have, a law that is partly constitutional and unconstitutional?
Well, the court has the basis under section 6 of the Constitution to say something is constitutional or unconstitutional. They have the right to interpretation. But my own bizarre worry has to do with the additional word that was used there in form of directive to the Attorney General that he should delete. He should delete. That statement is really bizarre because, number one, is it an order of mandamus you are given? Order of mandamus means order to compel somebody to do something he doesn't want. Is it an order of interlocutory order, or is it a final order? When you say he should delete, it means you have given him the power to make or unmake. That is the basis upon which whosoever can delete, it means he can insert or he can amend or he can institutionalize. That one is exclusively and squarely the power of the National Assembly. The power of the National Assembly under sections 4, 11, 8, and 9 of the Constitution of the Federal Republic of Nigeria. So I don't think the court is right in eroding the power of the National Assembly and then keep putting it on the Attorney General and bearing in mind even the case. The Attorney General is even a defendant. So I wonder how he will be compelled to say, go and delete this one. I think this time around, by the time we said, okay, delete, he has the decision, and we allow President to continue, then we will go into chaos. Because the Attorney General, who is in the strict sensu under the executive, will have the power to be making the decision. Will say, court has given me the avalanche to delete, court has given me the right to insert and do whatever. Then you will be in the confusion regarding who is the legitimate bearer that is supposed to be rightfully having the basis to delete or to amend or to insert or to remove or to add anything. Bearing in mind very fundamentally, Section 14, subsection 1 of the Constitution says sovereignty belongs to the people. And democracy is a game of respect to sovereignty, respect to popular wishes and aspirations of the people. And the bearers of this sovereignty under the canopy of representation are the members of the parliament. The members of the parliament at the federal level, at the state level, at the local government level are the bearers of the people's decision, because they are the ones elected from various constituencies from the nooks and corners of the Federation of Nigeria. As a matter of fact, even the National Assembly there, in order to make democracy perfect, under sections 8 and 9 says that they need to have 2/3 of the members of the state assemblies supporting any amendment they would like to make. And the 2/3 of the members of the state assembly, 36 states plus Abuja, is the minimum of 24 states. They carried out those things, they did it in decency and decorum. I think the court has really gone beyond my expectation when it really talked about the issue of delete or otherwise.
Very, very interesting. Now let's hear from Mr. Ayo. Now, in your assessment, what would you say would be the implication, for the implication of this, for the APC as we look forward to the convention in a few days?
Like I said earlier on, I am not a lawyer, but the implication could be grave. Should a court of a higher jurisdiction, maybe the appeal or Supreme Court, reverse this Jankara judgment, in my opinion, I don't think it's right. If the president didn't like it, he should not have signed that electoral amendment bill. Signing it means he has accepted, and then telling the National Assembly to take it off and they refuse, and then suddenly the Attorney General, with whoever was working in tandem with him, going to procure that Jankara judgment is a risk, a huge danger to the APC. Because should a higher court, probably the appeal, Supreme Court, nullify this overnight Jankara judgment from a Jankara UMUAHIA court, and I'm still coming back to this court.
Jankara. What is Jankara?
It is contempt of law, the use of the word Jankara you admit.
If this this judgment is nullified, it becomes a danger to the APC. And this is why I think, I don't know who is in charge of the judges in Nigeria. I think they should have a sit down, and we need to sanitize our judiciary system. I keep saying this because there was a time before we had this CECCP in the APC, when about 5 courts of the same jury, of the same power, federal high courts, state high court, were giving all manner of injunction. This one will go to Sokoto, get his own, bam. The next person rush to Bauchi, get his own, boom. The other one goes to Lagos, get his own, boom. Then it was a mess. And these things have been continuing, but nobody is looking at the danger. So if a state high court gives an injunction that I don't like, a decent person should naturally proceed to the appeal court. People don't do it anymore. You just look for another state where you can bamboozle or whatever is it that they do. Same level of court, of the same strength, because a state high court, a federal high court, they're all of the same powers. Rather than go to a higher one, you just look for another state where you, whatever it is that they do, I don't know, will get another injunction that is contrary to the other one. And these things have been going on and have been going on and have been going on. And if you check, it is mostly political cases. You hardly will see criminal or civil cases going this way. But the political cases, so politics is going into our judiciary, and it is risky, it is dangerous, and like I say, it is an harbinger to something very bad if something is not done. You will never see where somebody was sentenced because he committed a crime, and then rather than an appeal being filed, they go to another state and file the same case. It doesn't happen. But for the political issue, a state governor has an issue with somebody, or somebody has an issue with the state governor. They go to a court in the state. The case is decided. They will not go to an appeal court. What they do, they just look for another state or come to Abuja, get another court to give this to give a judgment on the same case that has been judged somewhere else. And this, for me, I don't know all the legal terms because I'm not a lawyer, but I have enough sense to know that this is a danger to our corporate existence. It's a danger to our democracy. It's a danger to even the judiciary itself, because it is losing a lot of credibility with this incessant and unholy attitude of dispensing injunction here and there without thinking of the repercussion on our national psyche.
Okay.
And on even our image as a country.
Okay.
If we continue to do this, I think we are losing it.
Okay, Mr. Ayo, now some have actually argued that, political appointees are not public servants, and also said that the National Assembly is a necessary party and has a right to set the decision aside on appeal. Now, do you think that this particular clause 84 is discriminatory against, political appointees and, just generally?
I don't think it's discriminatory, and I'll tell you why. Some of these appointees don't even belong to the political party before they were appointed in the first place. So why should they have right to choose and decide on to become delegates in an election where normally many of them were not even members of the parties? We've seen a lot of people who will tell you, look, I'm not a politician, I'm a technocrat. But they were appointed by maybe a president or a governor, and suddenly they now have the power to have a say on a political party that they naturally maybe don't belong to. So I think lawyers are creating a lot of confusion for us. You put 20 of them here, they give you 20 opinions on the same thing. But for me, anybody who is appointed does not necessarily have to have that automatic power to decide what happens in an election, a primaries election of a party that they maybe they don't belong to before they were appointed. Because the president or the governor who appointed you is a member of this party, you automatically have a say in what happens in the party. I don't think it's discriminatory. I think it is just right. And if you want to participate, resign and then go and participate. That way, you are now a political party member. You are now a politician. You go and pick the ticket independently without using the leverage of your office to get what doesn't belong to you or what you may not naturally get. So we've seen a lot of them, they went around behaving like they were demigods because they were appointees. And then when they leave the office, the power goes. So why should you use the leverage of your office to get something that you naturally maybe are not entitled to? So I don't think it's discriminatory. I think it's right.
Well, we'll continue the conversation, right after this break. Our guests will still be with us in the studio. Stay with us.
In all, 71 sections of the repealed 2010 Electoral Act were either reviewed, replaced, or new sections and subsections introduced. The essence, according to one of the resource persons at the workshop, Samson Itodo, is to guarantee electoral transparency, deepens internal party democracy, enhances candidate selection process, inclusion and voter participation, amongst others.
The Act also, I think somewhere in Section 9, also requires INEC to capture disability data disaggregated by the type of disability during voter registration. So that will help INEC in its planning and its deployment for election material.
Section 3, subsection 3 strengthens and secures INEC financial independence, while Section 41 introduces electronic voting. Section 47 confers legitimacy on electronic accreditation of voters, as Section 150 applies same treatment for area councils election as local government elections in Nigeria.
I have looked at Section 50, subsection 2 of the Act, and I've also looked at Section 65. In one of the sections, in Section 50, the National Assembly talked about transmission of results. In Section 60, they talked about transfer of results. Legally speaking and semantically speaking, there is a possibility that both of them don't mean the same thing.
Political parties under the new electoral law are in for a difficult time, as Sections 75, 82, subsection 5 introduce new timelines to meet, while Sections 29, subsection 6, 29, subsection 8, and 64, subsection 9 place heavy fines upon breach of provisions of the 2022 Electoral Act.
issues related to time of submission, time of withdrawal of candidates, issue of conduct of primaries. Conduct of primaries is one of the most controversial areas which has delayed the grant of assent by President Muhammadu Buhari over the Electoral Act 2022.
Other resource persons, Dr. Abubakar Kari, Jide Ojo, Dr. Shuabu Danwanka, Festus Okoye, and Ezenwa Wago, say the new piece of electoral legislation presents both an opportunity to right the wrongs in Nigeria's electoral processes and a recipe for increased litigations and conflicts.
The legal fireworks have already started in respect of Section 82, Section 12. Even though many people believe that it's a very good law, that it prevents appointees from eating their cake and having it.
What you used to have was that INEC officials can determine the outcome of elections. Electoral officers, the one they call EOs, can carry result sheets and ballot papers and bring to the home of a politician and print it.
As INEC prepares for off-season elections in Ekiti and Osun states, the efficacy and resilience of the new Electoral Act will be put to test, while the electorates hope for enhanced transparency and accountability in the process. Shafiu Suleiman, Trust TV News, Abuja.
This is Trust TV, documenting the Nigerian story.
All right, welcome back. If you are just joining us, you're still watching Daybreak on Trust TV. Our guests are still with us in the studio, senior lawyer, Barrister Menasar Okugo Umar, and also member of the All Progressive Congress, Ayolo. Now, Barrister Menasar, now I want to direct this question to you.
Yes.
A lot of people have actually argued in regards to the judicial proceedings we have in Nigeria. Would you say this case, further, exacerbates, the situation that everybody's talking about?
No, certainly this is one of the most confused legislations that, judicial pronouncement that have come during the polity. And politicians, like my brother rightly said, are using the courts as instruments of settling their own scores. And it's most unfortunate if we don't play game by the decorum, if we don't play politics by the rules of the law. Clearly speaking, when you look at it, it has a lot of repercussions. By the time you now allow this judgment to stand, which I am 100% optimistic, I believe there should be a stay of execution. And not only stay of execution, there should be a very serious appeal to overturn this judgment because of the consequential repercussions it will embody. One of the repercussions this judgment will bring is that clearly the culture of impunity as being practiced will continue. His Excellency, the governor or the president can just gather no matter what number of people he has. He can gather 3,000, 5,000, 7,000 people and come and tell them, say, go and vote for them. And you will discover that those votes that are under his hegemony, you will discover that they constitute over 70% of the total votes. So he is the one to determine where the decision of the party would be. Well, he is just a member of the party. By the time you strip him of this power, you have now brought him to a plain level ground with every other person. Everybody will go there with only his own single individual card as a delegate. And then secondly, I expected this Electoral Act amendment to have been appraised by the politicians, to even beg the National Assembly members to widen it so that more other amendments regarding the way to sanitize the political system should come. For example, appointees, we said, step aside. How about the elected people? There should be a mechanism of arrangement whereby whenever election approaches, 1 month to the election, His Excellency, the governor or the president should temporarily give it to somebody who will hold caretaker for him until the election is finished. Or even there should be law prohibiting use of state machineries for campaign and other things. You discover somebody using governmental vehicles, using the office paraphernalia, using the money and other things in the office, using all the acolytes of the supporting staff and other things, you know, perpetrating himself, campaigning for second tenure or for something that is higher. That one is clearly in violation of Section 15, subsection 5 of the Constitution that talks about the issue of the fight against corruption. It says the state. The state means the president himself, his ministers, the governors, the commissioners, members of ministerial department and agencies, all appointees from the president down to messenger. When you talk about the state, it is the totality of that. It said the state must fight all forms of corrupt practices and abuse of power. It's a clear case of abuse of power whereby you are on your seat, you are perpetuating yourself on seat, you are contesting for the second tenure, or you are contesting for a position that is higher using state machineries, state funds, state materials, state personnel, and state institutions. Definitely that aspect too should have been checked, should have been checkmated in such a way that it should be reduced into the DC. And even the members of the National Assembly, you will discover that from 1999 to date, there are some people that have turned the National Assembly as their basic rights. They have been there, elected, re-elected, further re-elected, more re-elected. They have been there whenever there is any election. They now pronounce that there is no vacancy as far as their constituency is concerned. They remain the people there. National Assembly members should have limitation of tenure. There should be limitation of tenure regarding when to serve and allow other people to come and serve. The democracy as a whole, if we are to be sincere, it needs serious clinical surgery in Nigeria, serious clinical examination, and there is no better way to do it like the way the National Assembly is doing it, because they are the ones given the power to do it, even though they too, they don't want to choose those things that fall within the square peg of their interest. For example, people have been complaining about the jumbo package they are enjoying. That money they are enjoying is not in tandem with the comatose economic realities of the nation. There is no reason why they should be taking that huge issue. There's emoluments they should be taking should be on the basis of part-time practice, and then the two chambers should be collapsed into one chapter, one chamber of the National Assembly, so that as you have unicameral at the state, unicameral at the local government, it should have uniformity of having unicameral at the national level too, and it should be clearly based on part-time, and there should be limitation within which to serve. There are a lot of things that the polity needs serious something, but in a situation whereby the judiciary, which like my brother rightly positioned as the last hope of common man, is allowed to be the instruments of self-promotion, self-protection, and self-aggrandizement by the political power players, then it's most unfortunate, because if you lose the hegemony of the judiciary as the institution to come and sanitize, and it turns out to be an instrument under with the whims and caprices of the politicians, then I wonder what the future of our political power play and what lessons Nigeria is showing to other countries in Africa and the entire black world.
All right. All right, Barrister. Now, Mr. Ayo, now in your opinion, what do you think is the future of this particular clause 84 subsection 12, and especially now considering the fact that the 2023 elections, are actually, close? Do you think it will have an impact or an effect on
I just
the
hope
elections?
that there will be no chaos in the coming days, because if we continue to have this mixed communication coming from the judiciary is acting like if there is a chaos in the system, it will not affect them. Just like the way I blame you journalists too when you sensationalize and create all these bubbles. You see, the thing is, I believe in the Yoruba saying that when the heavens crashes, it will crash on everybody. You see, we need to not act like there's no tomorrow. And that has been the way politicians, the judiciary, everybody has been acting. Nobody cares that these things will have a repercussion. And if it does have one, how will it affect the general polity? How will it affect me as a person? Everybody is just thinking of what do I stand to gain right now. Nobody is looking at just the immediate future, not even the long-term future. Because this, for me, is an abinga to chaos and a chaotic situation in a short in the short while from now. Whatever is not right, no matter how much you shout very loud about it, it is still not right. If I look at this, my sister here, and say, you are wearing a white dress, and I'm very loud about it, it won't change the fact that she's wearing a black dress. My noise about the fact that she's wearing a white dress, and I can go to everywhere and shout it, does still not change the fact that she's wearing a black dress. So the fact that these things are happening, and people think they can do anything because they are in power, or because they have the ears of the court, because I'm still wondering why a case where the National Assembly made a law in Abuja, and we couldn't find any court in Abuja to handle the case, it has to go to UMUAHIA. It is ridiculous, even if we don't want to say because we're on air. It is ridiculous, it is disgraceful. It shows that there is compromising on both sides. And like the senior lawyer rightly posited, who is the complainant? Because I don't know how they call this plaintiff. I don't know how they call them. Who is the person? How does it affect this person? I cannot, for instance, go and file a case on something that I have no standing or local standing on, like they call it in their legal parlance. So as far as I'm concerned, people are just running amok like headless chicken. And when the headless chicken runs into the road, we know the problem it creates in terms of traffic. So this clause, and this, you see, I shouldn't call it Jankara judgment anymore, but honestly, as far as I'm concerned, it's an embarrassment. It is going to create a problem if we continue to behave as if we are all not thinking. We're a country of 200 million people. If you follow the trend, there is a story that says Nigerians in the United States, in diaspora, are the most educated group of people. So it tells you that we have something. But why is it that it is the most unintelligent of us that makes decision for the rest of us? Because sometimes, like he rightly said, how does the other country look at us? When we behave like, I don't want to use the word idiots, but this is what we are doing to ourselves. We're supposed to be space setter in Africa. We're supposed to be the most important country in Africa. We've had senior people, Julius Nyerere has said this, we've had Nelson Mandela saying that Nigeria must lead Africa. But we are actually behaving like children and ourselves. So if we continue to behave like this, how do the other countries look at us? Do we look like a serious bunch of 200 million people, or a bunch of 200 million idiots? What are we telling the people? If we are supposed to be the most educated people, the most advanced Africans, the generation of Africans that should lead the remaining Africa, and we can't even lead ourselves, what are we telling the world? So for me, this thing is disgraceful, and I will still say it. Whoever is in charge of judges, lawyers, they should sit down somewhere and tell themselves the truth. If they want this democracy to survive, we must stop this judicial rascality. Because if we do not do it, you might think we have passed the age of violent takeover of government. But we saw something close to it almost 2 years ago. We need to clear out the audience table so that people have confidence that whatever the courts are pronouncing is the right thing. Right now, he is a lawyer, he doesn't agree. I'm not a lawyer, I don't agree too. So if everybody is saying that the judges and the courts and the lawyers and everybody is behaving anyhow, and people lose hope in that aspect of our national life, I'm sure you know the danger that portends for all of us.
Where do we turn to?
So we must beg these people so that they do not plunge us into an unnecessary chaos, to stop all this rigmarole, to stop all this disgraceful and irresponsible attitudes. Because we are civil people here. If the world can see Nigerians as the most educated group of people outside their country, why is that the ones within the country are acting like the most stupid rather than the wisest? It is something that you can't put together. It doesn't make sense. Nigerians go outside the country and they rule the world. And Nigerians within their country cannot rule themselves. So is it not a conundrum?
It is.
We need to find a solution to this and stop this nonsense, because it is not acceptable by every human standard, religious, moral, social standard. It is not acceptable, and we shouldn't accept it.
Very, very interesting. Now let's get to your final thoughts, Barrister Mainesra, quickly now in just
Yes.
2 seconds.
Yes,
before we
my
wrap up.
final thought is that 23 years into democratic experiment, we are still like toddlers. And simply the reason is because we have failed to really give the definition, to understand the definition of politics. Politics is a game of service. A politician is taking politics as a game of investment. A politician is supposed to be somebody that is matriculated into class of the excellent class of the servants of the nation, so that they will graduate ultimately as statesmen. How many politicians now are having the qualities of statesmanship? How many of them are statesmen? For the Attorney General, what type of legacy do you want to leave when you leave office with this type of records of judicial practices under your own stewardship as the Attorney General of the Federation? Politicians should take politics as a game of service. You should consider yourself as the vicegerent, as the representative of God on earth, to maintain natural justice and equity, to make sure that you are the representative of God, to ensure sanity in the way people are governed, to give everybody what in the Constitution. If you take the provision of sections 14, subsection 1 and 3, sections 15, 1, 2, and 3, sections 17, section 18, sections 21, 22, and 23, and 24 of the Constitution, all talks about natural justice, equity, and balanced fairness. When you give judgments like that, that to the average or Nigerian, he will just be laughing at it. He doesn't believe that it is a judgment. Then we are in for trouble,
All right,
because we are
thank
in
you so
for
much,
chaos
sir.
and confusion,
We've
which will
actually
really
run
not
out
be
of
good
time
for us.
right now. Thank you so much, sir.
I
Thank
just
you.
want to say, if I ever need a lawyer, I'm going to hire him. I like him.
Oh, interesting. Barrister, if you have a client already. Well, thank you so much for coming on Daybreak this morning. We've been speaking with a senior lawyer, Barrister Mainesra Kogo Umar, and a member of the All Progressive Congress, Ayo Oyalo. We hope to have you next time, gentlemen.
Thank you.
Thank you, thank you, thank you.
Well, with that, we wrap up Daybreak for today.
All right, thank you so much for tuning in. We'll be back again tomorrow, same time, same station. I'm Dashan Husseina Usman.
And I'm Zainab Bala. See you tomorrow.